Once you have got to the stage in a litigation where the matter has been determined and an award of expenses has been made, the unsuccessful party may look to appeal. The procedure adopted depends on whether your action is in the Sheriff Court or in the Court of Session. Since January 2016, appeals from the Sheriff Court must be brought to the Sheriff Appeals Court. Where the decision of the Sheriff is a final disposal of the case, whether that's after a proof where evidence has been heard or at a procedural hearing where legal arguments have been canvassed, the appeal is made without the leave of the Sheriff who made the decision. It must be made within 28 days after the date on which the decision was given. A note of reasons of the decision from the Sheriff whose decision is being appealed must be obtained, and then the appeal is intimated to the other parties and sent to the Sheriff Appeals Court. The Clerk of Court will then issue a timetable setting out the procedure to be followed. Appeals beyond the Sheriff Appeals Court will require leave of either the Sheriff Appeals Court itself or the inner house of the Court of Session to whom the appeal is made. Where the Court of First Instance is the Court of Session, the appeal is made from the outer house to the inner house. The process is known as reclaiming, and it's made in the form of a reclaiming motion. There are 3 general time limits depending on the type of decision being reclaimed. Interlocutors, that's what we call the order pronounced by the Lord Ordinary, and they may be reclaimed within 21 days after the date on which the interlocutor was pronounced. Certain other interlocutors that do not dispose of the whole case may be reclaimed without leave, but within a 14-day period, and these include interlocutors granting or refusing interim interdict and interlocutors disposing of part of the merits of the case. In all other interlocutors, leave is required and the reclaiming motion must still be made within 14 days, so the leave must be obtained within that period. Once the reclaiming procedure is underway, the court will issue a timetable specifying various procedural steps, such as the lodging of the grounds of appeal and answers, notes of argument, any appendices containing the material that's to be relied on. Like in England, new evidence can only be submitted if it could not with reasonable diligence have been available during the original hearing, and of course, it must be relevant to the matters at hand.